In this video, we're going to discuss how to enforce one's patent rights. As we talked about in prior videos, a United States patent gives the patentee the right to exclude others from making, using, selling, offering to sell the patented invention anywhere in the United States. Now, it may be the case that other parties know about your patent and choose to respect your patent rights and avoid from competing against you in the marketplace. But it also could be the case that they go ahead, either because they don't know about your patent rights or they choose to take on the risk of infringing your patent and sell a product that infringes your patent rights. Now, you need to know that for patent enforcement, there is no government agency that will enforce patent rights. It's incumbent upon the patent owner, the patentee, to enforce that person's patent rights either in federal court or the International Trade Commission. Now, much like the games played on the athletic campus behind me, patent litigation is a hard-fought and high-stakes event. So let's go through the chronology of potentially enforcing one's patent rights. The first thing to know is that before you send someone a cease and desist letter, let alone sue them in court or the International Trade Commission, you need to perform a pre-litigation investigation. This is because you can't seek to enforce your patent rights unless you have a reasonable and good faith belief that in fact the other party infringes a valid claim of your patent and you in fact own those patent rights. So you need to perform a reasonable investigation to make sure that you have a good claim against that party. Next, you usually contact the other party to see if they'll abide by your wishes. This is usually done through a cease and desist letter or a licensing offer, some sort of communication to make them aware of your patent rights and your belief that they infringe your patent. Now, you need to know that once you contact another party, you very well may give them the ability to start the lawsuit themselves. They can do this through what's called a declaratory judgment lawsuit, commonly called a DJ action. This is where they go into court and they ask the court to declare something. For example, that your patent's invalid or that they don't infringe your patent. Now, you'd also have the right to cross-sue them for patent damages, but by initiating the action themselves through a DJ action, they can probably pick the form they want, and it could be a form that they perceive as being favorable to them. So, before you go and contact someone to initiate a patent enforcement claim against them, you need to make sure that you're ready to jump in and engage in full-scale patent litigation, because that very well may be what you're triggering through sending them a communication about your patent rights. Patent litigation takes place either in federal district court or in the International Trade Commission. The International Trade Commission handles actions involving the import of a good that potentially infringes the United States patent. Unlike cases in federal district courts that can be tried before a judge or a jury, International Trade Commission cases are only tried before a jury, and one can only get an injunction, a declaration that someone has to stop infringing your patent rights. You can't get monetary damages before the International Trade Commission. But International Trade Commission cases tend to proceed more quickly than federal district court cases. There tends to be some significant differences in district courts in how they handle patent cases. Some district courts are more familiar with patent actions. Some district courts proceed more quickly. For a long time, people would seek to file cases in the Eastern District of Virginia, which was known as the Rocket Docket, because it could process cases extremely quickly, sometimes within a year, as compared to other district courts that could take up to 3 years to process a patent litigation matter. Many cases are filed in the Eastern District of Texas, where it's perceived that there's procedures and a jury pool that views patentees more favorably. So these are some things to consider before selecting to bring a patent litigation action in a particular district court. Now, once a case is filed, you'll typically file a complaint. The alleged infringer can respond with an answer to that complaint. There may be some preliminary motions filed challenging the adequacy of one's complaint or one answer, but eventually there'll be what we call discovery. And this is the massive exchange of information that takes place in American litigation, where you can pretty much get any piece of information from the other party that you believe is likely to lead to the discovery of admissible evidence. And this involves a massive exchange of documents, including electronic documents like emails, the exchange of written questions the other side has to answer, which we call interrogatories, and the taking of depositions, which is the question and answering that goes on, similar to cross-examination or a direct examination of a witness, but this takes place before court, under oath, with a court reporter present to record the questions and the answers. So you typically know what a witness is going to say before you actually get to the trial. This is extremely time-consuming and expensive. It's important to note that even besides the drain on capital resources, patent litigation is a huge drain on your own time and resources because when your employees are being taken for depositions or being asked to produce documents and emails, this is obviously distracting from your core mission as a business. Eventually, there's going to be something called a Markman hearing. This is the name of a hearing where the judge will actually construe the claims. We talked about earlier how the claims of a patent, which define the scope of the patent rights, are really just words. And a judge is going to tell you what those words mean by reviewing the patent document, the prosecution history, and written submissions from the parties. After the court construes the claims, there's probably going to be summary judgment briefing where each party's lawyers submit briefs arguing that the judge can rule on the case now, that based upon the facts the parties generally agree upon, this is clear and the court can rule on certain issues in the case. At some point, there's going to be expert discovery. Experts, again, are extremely expensive and they can give expert opinions on issues like infringement, the validity of a patent, sometimes inequitable conduct, and quite often damages. An economic expert going through how to calculate the lost profits or what a reasonable royalty should be if the patentee is successful in the eventual trial. And then eventually, in a small portion of the cases, you will get to a trial where you actually try the case before a judge or jury. As you can imagine, this entire process, again, is extremely expensive and can take a very long time. So patent litigation is really something that startups and entrepreneurs should avoid at almost all costs because it's going to be hugely distracting and extremely capital and time intensive. It's also important to know that in American litigation, generally, each party pays its own fees. So when you get to the end of the case, whether you're the winner or the loser, you're on the hook for your legal costs and fees, which, as we'll talk about in the next video, can be quite high, usually in the at least tens of thousands of dollars a month, and quite often in high stakes cases exceeding $500,000 and into the millions per month that you're paying your law firm to proceed in patent litigation. So again, it's something that startups and entrepreneurs want to avoid at almost all costs, but if you do have to engage in patent litigation in order to enforce your patent rights, hopefully you're like the Wolverines playing in the big house behind us and you're victorious.